You're listening to FairPlay on justicenews.net.
Welcome to FairPlay. I'm your host, Imran Siddiqui. Today, we're looking at the case of Lydell Grant, who spent more than 9 years in prison for a murder he did not commit. And joining me today to talk about this case is Lydell's attorney, Mike Ware, who's a criminal defense lawyer based out of Fort Worth in Texas. Mike is also an adjunct professor at the Texas A&M School of Law and is the executive director of the Innocence Project of Texas. Thank you for joining me, Mike, and welcome to FairPlay.
Thank you very much for having me. I really appreciate it.
Well, we appreciate your time. What is the background of Lydell's case and what made you pick it up?
Lydell was falsely accused of a murder back in 2010. And the brief circumstances were that there was, in fact, a brutal, really public murder that took place in the Montrose area of Houston, Texas, on the night of December the 10th of 2010. It was a Friday night. There are a lot of nightclubs in the district, and this murder happened to take place on the parking lot of one of the nightclubs in front of a lot of witnesses.
Okay.
6 of which ultimately testified in the case. The victim came running up the steps of the nightclub, I think it's called Club Blur, and begged to be allowed inside, said someone was trying to kill him. The bouncers turned him away, said, "You guys just keep it outside."
Wow.
And ultimately, the perpetrator caught up with him, tackled him, they wrestled. The perpetrator stabbed him several times, beat him.
Wow.
At one point, the victim got away, ran, but was tackled again and was murdered there in front of several witnesses. The perpetrator then walked off into the night. No one knew either the victim or the perpetrator. Obviously, the police were called. Eyewitnesses gave recorded interviews over the next 12 to 24 hours. There were no known suspects. The victim was identified. People knew him. He lived in that area. No one knew, but still no one, even the people who knew the victim had no idea who would have done this.
Okay.
And no one knew where the victim had been or what he had been doing for the hours leading up to this that might, cause something like this to happen. And so I guess for about 24 hours, the case was completely unsolved. Mm-hmm. Now, the following evening, which would have been a Saturday night, Mr. Grant was parking his car in that very parking lot where the murder had taken place. Of course, he had no idea that a murder had taken place in that parking lot 24 hours before. He knew nothing about the murder. He, in fact, had an alibi, as it turned out, for where he was and who he was with the night before when the murder had taken place. But one of the bouncers or one of the workers from the nightclub saw him and thought he looked similar, at least, to the person who had committed the murder in that parking lot 24 hours prior, and called Crime Stoppers, and I believe collected a cash reward ultimately. But he reported that he saw someone who he believed similar in appearance to the murderer, and he somehow got the identifying number of the vehicle Mr. Grant was driving, and reported that as well. And the investigators on the case were able to put Mr. Grant with that car and ultimately put his photo in a 6-person photo spread and got, I guess, 6 of the witnesses to pick his photo out of the photo spread as the person they saw commit the murder. And Mr. Grant was arrested, I believe, the following Monday after the Friday night murder based on this. And of course, immediately the media and the police proclaimed that they had caught this guy. And, if you read the media accounts right after the arrest, they described the crime in terms of first Mr. Grant did this, first then Mr. Grant did that, then Grant did this. Then they don't even say the perpetrator. They don't even say a suspect. They just tell the story as if it has been decided that Lydell committed this murder. And, of course, they get that story from the police.
Wow. Unbelievable. What were some of the most shocking things for you in this case?
Interestingly, early in the investigation, there's a notation in the investigative report that says that the fingernails of the victim should be collected at the autopsy so that they can be tested for foreign DNA, because in a murder that involved a hand-to-hand struggle, the DNA in the fingernails could be very probative as to who committed the murder, just as the DNA from a sexual assault kit can be very probative of who committed the sexual assault. And so a note was made in the investigative file that the fingernails should be collected at the autopsy and tested for foreign DNA, and whatever profile that might reveal should be compared to any suspect and to put into the national database. Now, that was done in 2011 by the Houston Police Department Crime Lab.
Mm-hmm.
They tested the fingernails, and I believe it was the right-hand fingernails had a mixture of two donors of DNA, and one of the donors was the victim, which, of course, you expect to find the victim's DNA in his body part, and the other was an unknown male donor. And ultimately, the testimony at trial, of course, the 6 eyewitnesses identified Lydell Grant as the perpetrator, there in the courtroom. That's always a very dramatic moment. Many times, as in this case, it's total BS, but it's very convincing to a jury for, the nervous or frightened witness or victim to point to the defense table and say, that's the perpetrator over there, wearing, whatever, sitting next to his or her defense lawyer. There's no doubt in my mind. I would not forget that face anywhere. Well, many times that's BS, but it's very effective to a jury.
Yeah.
And it worked in this case, and just, multiply that times 6.
Wow. Is that it, or there's more to this?
And then the police crime lab forensic person got on the stand and testified inaccurately that, number one, testified that there was a mixture, of DNA donors in the victim's fingernails, and that the victim could not be excluded as one of the donors, but also testified that Lydell Grant could not be excluded as the other donor. And so, of course, that didn't help his case at all. And he was convicted. He lost his appeals. He filed one writ, I believe, before he contacted us. He lost that. And then he contacted us, the Innocence Project of Texas. And in 2018, I assigned, his case to one of my students. Usually every semester I have, about 12 students in my clinic, and each of them get a case. And his was one that I assigned. And then we discuss them in class. And in discussing Mr. Grant's case in class, and looking at the written materials we had been able to collect and gather in reviewing his case, we could clearly see that he was excluded as the foreign donor of male DNA in the victim's fingernails.
Wow.
And so, having seen that, we went back and looked at the testimony, the trial transcript, to see how they had dealt with that at trial. And what we saw was that the state's witness basically just lied.
So basically,
that may be a strong term. Basically, testified inaccurately, because even
a strong term, but the truth that he lied.
Well, it was she.
She.
It wasn't he.
Okay.
But it was couched very carefully, and other forensic people have sort of defended the testimony, but the students and I could see that he was excluded from the mixture. So why, to me, that's what the testimony should have been.
Yeah.
And the defense attorney did not cross-examine on that. The defense attorney pretty much accepted that.
Mm-hmm.
And so, it's been my experience that when, and usually that's the problem with having forensic labs connected with police departments. The police go in there and they tell the forensic person what to testify to. Mm. And, of course, there's an incredible pressure on them to testify the way the police tell them to, because they're part of the police department.
Wow.
And so I something like that, I'm sure, happened in this case. We can't prove that. We just know that the testimony was not accurate, and it was very damaging to Mr. Grant. And had it been accurate, it would have been very helpful to Mr. Grant.
You're listening to Fair Play on justicenews.net. You're listening to Fair Play on justicenews.net.
Welcome back to Fair Play. I'm your host, Imran Siddiqui, and today we're speaking with criminal defense attorney Mike Ware, who represented Lydell Grant in his fight against his wrongful conviction in 2010 for a murder he did not commit, but spent time in prison for that. How important of a role did DNA evidence play in this case?
The foreign profile was never put into the national database by the police, as the investigative report recommended. Or at least as far as we know, it never was.
Wow.
Now, you could say that back then, the technology was such, it was difficult to get a profile from a mixture that was CODIS eligible. That CODIS is the national database that it should have been uploaded into. And there are all kinds of rules and regulations. It's possible that at that point they could not unwind the mixture sufficiently such that it would have been eligible for a CODIS upload.
Okay.
But in any event, you can see on its face that Mr. Grant is excluded from the mixture. So it's been my experience when prosecutors have to fudge the truth or elicit lies in court, that's a red flag.
Yep.
It doesn't necessarily mean the person is innocent. It could just mean that, the prosecutors, believe that the person is guilty. They are guilty, and that being the case, they believe the ends justify the means. But sometimes, when they're fudging the truth or stretching the truth or out and out lying, that can be a red flag that maybe someone's actually innocent. Because otherwise, why do they have to lie to get a conviction?
Yeah.
Why do they have to fudge the truth to get a conviction? So we explored further, and we were able to get the raw data from the original 2011 testing of the fingernails.
Did they try to push you back?
There was some talk about retesting everything, but my particular opinion at the time was, why do we need to retest everything? The test from 2011 excludes them. So why, the testimony at trial was false. Why do we need to retest it? Let's get a second opinion on the raw data that generated the report from 2011 that was testified to in 2012.
Unbelievable.
So we did that. We got the raw data. We hired a DNA expert in this field, Angie Ambers, and she facilitated us getting the raw data to a company called Cybergenetics in Pittsburgh, Pennsylvania. And Cybergenetics uses, a software that uses algorithms to unwind DNA mixtures from raw data. It's called probabilistic genotyping.
Wow.
And law enforcement labs use the same type of software in unwinding mixtures. In Texas, all the law enforcement agencies use what's called StarMix, but it's a very similar software program to unwind DNA mixtures. Now, that was not really available back in 2011, in all fairness, but in 2019, when we got the raw data, it had become the best practice the recognized best practice for unwinding DNA mixtures.
Wow.
And so we sent it to them, and they were able to unwind the mixture and come up with a number one, they definitely excluded Mr. Grant from the mixture.
That's heavy.
And they were able to get a sufficient profile of the unknown donor so as to have it uploaded into the CODIS database.
Whoa.
At that point, we had Mr. Grant being excluded as opposed to what was testified to at trial from the DNA mixture. And we have an unknown donor. We don't know who it is. Well, it was uploaded into CODIS. I don't know, within 10 days, we're notified that there's a hit, that the unknown donor from the fingernails matches a known offender whose profile has been uploaded into the CODIS database.
Wow.
And it turns out, of course, then you go, well, who is this person? Is pretty much matched or certainly fit within the range of descriptions that all the witnesses gave. Same age, same height, same weight, same race.
And that was Jermarico Carter.
Correct. And so now, not only is Lydell excluded, but we know who did it, whose DNA it is under the fingernails. He was in Houston during that period of time. Understand, we're talking about 2019, but in 2010, he was in Houston. He had been arrested very close to the spot where this murder had taken place for, I think it was a drug-related incident. He had been in jail in the Harris County Jail, but he was not in jail at the time that this murder took place. And, further investigations show he had left Houston pretty soon after this murder took place and was in the Atlanta, Georgia area. So we took that information to the district attorney's office in the summer of 2019. Now, simultaneously, the district attorney's office had wanted to retest the fingernails clippings with the Texas Department of Public Safety lab. So we said, that's fine. And, y'all can do that. But, in the meantime, we're going to do, what we did do. And so when we got back to them with that information, they still didn't have the results back from the Texas Department of Public Safety.
Really?
And so I guess they were skeptical about what we were telling them.
Man.
But by August, DPS had come back with their results, and they agreed that Lydell Grant was excluded as the foreign donor. But they said that they were not able to get a sufficient clear profile of the additional donors so to upload it into CODIS. Well, we had already done that and gotten a result.
Yeah.
I guess I'm glad we didn't have to rely on the Texas Department of Public Safety.
True.
But anyway, they did agree. They did agree that that Lydell was excluded. So to that extent, they were consistent.
Mm-hmm.
We asserted that was favorable DNA results and that he should be out on bail. We scheduled the DA's office at that point was contesting bail.
Wow.
We scheduled a hearing. The DA's office showed up and claimed they needed a continuance. So we didn't, we had his whole family there ready to testify, and others, friends and such. So we didn't have a hearing, and he stayed in jail.
Unbelievable. We
said, okay, well then if you're not ready for this hearing, then let's set it for another hearing right now. And so we set it for a hearing at what would have been, I guess, the day before Thanksgiving of November 19. Shortly before, a day or two before the hearing, the district attorney's office called me and said they would agree to a bail. And so we didn't need to have the hearing. And so they agreed to a $100,000 bail.
Wow.
So we said, okay, it's time for Lydell to get out. And we managed to raise enough money that a bail bondsman made his bail.
Wow.
And he was released and out before Thanksgiving of 2019.
And then the actual killer confessed.
In December of 2019, on the Friday before Christmas, I think Christmas was the middle of the next week or something. I got a call from the district attorney's office, and they said that Carter had been arrested in the Atlanta area, and I guess was in the Fulton County Jail, and that the two Houston Police Department cold case detectives who had been working on the case had flown out there, and they had interviewed him in a video-recorded interview, and that he had confessed to the murder, and that they were going to agree to relief on Lydell's case.
Wow. And
so we quickly moved to get proposed findings of fact and conclusions of law. The way the procedure works, you've got to present those to the district judge, of the original court of conviction. He signed off on our agreed findings of fact and conclusions of law that Lydell was actually innocent. And I believe it was before the end of the month, before the end of December, if not, it was early January. Those had made their way to Austin to the Court of Criminal Appeals, on agreed relief. I expected a pretty quick turnaround. I mean, this is kind of a no-brainer, particularly since everybody agreed. The police agreed, the DAs agreed, the judge agreed. And, it was a DNA exoneration, and there was a confession by the actual perpetrator. I mean, it was, a no-brainer. I expected a very short, perfunctory opinion, and everybody would go on to the next case, and Lydell would go on with his life. But in April of 2020, they sent back an order saying they wanted to view the confession videotape, and to please send them the confession videotape. Well, I thought that was kind of odd, I mean, did they think we were lying about it? I mean, what was the deal? And they just have idle curiosity. So we sent it to them, of course, and waited, and then in July they sent back another order, and I think this was, right before they broke for the rest of the summer.
Wow.
And I sent back another order saying that ordering the district judge to order the 6 eyewitnesses to give affidavits about what they thought about Mr. Grant's claims of innocence.
Wow, they just didn't want to let him go.
I don't know. It was, everybody agrees they had never seen anything like that. I mean, we have, Mike Hall did an excellent story for Texas Monthly, and he interviewed former judges from the Court of Criminal Appeals, and they said they had never seen anything like it. So it's not just me saying that.
This is Fair Play on JusticeNews.net. This is Fair Play on JusticeNews.net.
Welcome back to Fair Play. I'm your host, Imran Siddiqui, and today we're speaking with criminal defense attorney Mike Ware, who represented Lydell Grant in his fight against his wrongful conviction in 2010 for a murder he did not commit. You have called Lydell's case the most outrageous thing you've ever seen. Why do you think that is?
That's specifically referring to the Court of Criminal Appeals ordering the 6 affidavits from, or the judge to order the 6 eyewitnesses to give affidavits. I've handled a lot of DNA exonerations.
Mm-hmm.
I've never seen that. I've never seen, if someone is convicted on the basis of eyewitness identification, and then the DNA proves they didn't do it, then that's the end.
Yeah.
And sometimes victims are very skeptical and claim that the wrong guy's been let go, that they were right all along, or eyewitnesses are skeptical, but it doesn't matter. They were just wrong.
You can't argue with DNA.
Right, because the science proves that they're wrong.
Yeah.
Well, particularly when we know as much about eyewitness identifications, we now know it's not reliable.
Yeah.
Particularly if they've been manipulated by the police or by the prosecutors, and so it really, at that point, it doesn't matter what the witnesses say.
Yeah.
And the Court of Criminal Appeals wanting us to get affidavits from the witnesses indicated to me a naivety at best, and totally uninformed, at worst. And this was a clean exoneration. Why did they want to send us out to try to muddy it up with who knows what these witnesses would say at this point? They would probably be very defensive about their choices. Nobody wants to say their mistaken testimony put an innocent person in prison. Why did they want to publicly embarrass these witnesses? Why did they want to interfere with the prosecution of the actual perpetrator, which their order very much did interfere, or potentially could interfere with the prosecution of the actual perpetrator?
To punish them.
Well,
how dare you come up and say all these things?
There's lots of things about the case that are tragic and terrible, but what I was referring to when I said outrageous, that's specifically what I was referring to.
Knowing Grant is not your first, and hopefully won't be your last exonerate, why is it so tough to get an innocent man out of prison?
Well, for a number of reasons. One, until the DNA exoneration started happening in, the 90s and into the 2000s, no one that was part of the system would admit that an innocent person had ever been convicted. Mm-hmm. Maybe there's the occasional famous case, but other than that, it was pretty much considered to be a movie or TV thing where innocent people got convicted, but not in real life. Now, the DNA cases changed that completely, changed the narrative on that, because once you study those DNA exonerations, you see exactly where the system went wrong, and you see how terrible the system can be, and you see how innocent people were railroaded. And you just have to wonder how common that is in cases where there is no DNA.
Yeah.
So I think even today we're still fighting that bias that, the system gets it right, 99.99999% of the time. And so we're going to go with finality. There's also a bias about embarrassing the people in power, and it's, of course, people in power that put people in prison.
Mm.
And every time the people in power are shown to have put an innocent person in prison, they're either embarrassed or they should be. I think some of them are beyond being embarrassed, but and could care less. But there's a reluctance for people in power to embarrass other people in power. I think there's a reluctance of the Court of Criminal Appeals judges in power to embarrass, powerful district attorneys, powerful assistant prosecutors, powerful police unions. So I think there's that going for it too. Plus, the law is in Texas anyway. The Court of Criminal Appeals made this law that it is a Herculean burden to prove that someone is innocent once they've been convicted. And so we've got strong cases that have been turned down because they say, maybe it's more probably than not that this person's innocent, but you haven't met your Herculean burden to prove that this person is innocent. The law favors finality, even if it's the wrong result. The law makes it very difficult. Oftentimes, unfortunately, wrongfully convicted individuals will file their own pro se writs, And the law in Texas, and it's pretty much everywhere, that once you file one writ, even if it's a pro se writ filed without an attorney, that's your one bite at the apple. So they lose their homemade without an attorney pro se writ, and then attorneys can't do anything for them because they've already used their one bite at the apple, so to speak. So there's a number of things that make it very difficult, both legally, philosophically, politically, etc., that make it difficult to win these cases.
And you think that's also tied to the fact that to be able to make a better example, we never see a corrupt judge or a corrupt prosecutor being prosecuted?
Well, we just recently got one. I say we did. One of our exonerees, Dennis Allen, out of Dallas.
Yeah, that's true.
Has been exonerated, and the prosecutor in his case.
Isn't that rare news?
It is. I guess that's why it made the New York Times and the Washington Post, and not just the Dallas Morning News. The prosecutor in his case hid exculpatory evidence, and a grievance was filed, and he, for whatever reason, voluntarily gave up his law license.
This is Fair Play on JusticeNews.net. This is Fair Play on JusticeNews.net.
Welcome back to Fair Play. I'm your host, Imran Siddiqui, and today we're speaking with criminal defense attorney Mike Ware, who represented Lydell Grant in his fight against his wrongful conviction in 2010 for a murder he did not commit. What do you think is the role of DNA evidence in exonerations, and what about those who can't afford it?
If someone comes to us and it is, DNA is not the answer in every case, but if it is a case in which DNA testing would be appropriate, then we will pay for the test if there's no other way to get it done.
Okay.
Now, sometimes we have to meet some legal hurdles. Many times we run into a district attorney's office that opposes a test.
Oppose a DNA test?
Yes, often they will oppose a test.
Why would they do that?
Well, they don't want to give the defendant an opportunity to prove that they're innocent.
Wow.
If they can deny them the opportunity to prove that they're innocent, then they can never prove that they're innocent, and they will never be embarrassed.
So do you think our criminal justice system is, at its core, unjust? It's a pretty radical question, you think?
Well, certainly you can show with anecdotal examples of how it has been very unjust, and you can show with anecdotal examples of how it has been very just. So it's certainly, I think that racial bias and prejudice is very much a part of the criminal justice system, and to that extent, it's unjust. And I would say it is at its core racist. Now, but talking about whether it's just or unjust, I'd be more comfortable looking at it on a case-by-case basis and say, it was unjust here, unjust there. Well, it was just there.
Yeah.
But I would agree that it is at its core racist and biased against marginalized demographics.
Marginalized against poor people and people of color.
Yes.
I was talking to an exoneree, and he was saying that according to his research, about 50,000 or more innocent people are currently wrongfully incarcerated and trapped in our unjust justice system. What do you suggest those guys should do?
Certainly, if they're in Texas, they can write us, and we get, maybe 100 letters a month. We're not, we're a small nonprofit, so we're limited in what we can take on, but I don't know what to tell them other than not to give up hope. And if ground truth is that they are innocent, if that is the fact and that is the truth, then eventually there should be a way to be able to prove that, because facts are very stubborn things, as John Adams once said, and the truth doesn't go away. So, and the truth has a strength all its own. So if the facts are, and the truth is that they are innocent, that they did not do it, don't give up. And eventually, they should be able to prove it.
What do you think it will take to reform the criminal justice system?
There's a lot. First, I think the people in power, such as at the state legislature, need to understand that the people they represent want the criminal justice system reformed, because until they believe that they may lose an election if they don't reform the criminal justice system, they're not going to reform the criminal justice system. So I think it's going to take an awareness of the voting citizenry that is something that is important to make this society a better place, and that they are going to vote for the candidates who are going to help reform the criminal justice system, as opposed to the candidates who are just going to help corporations get richer. Then that's what it's going to take. I was elated to see that Larry Krasner was reelected, at least at this point, reelected in Philadelphia as their district attorney, because he was undergoing vicious attacks by the police unions and others. And the people of Philadelphia spoke. They believe that criminal justice reform is important, and went to the polls and reelected him in spite of the vicious attacks by the police unions up there. So I think that's what it's going to take.
How does it feel to help free the innocent? That is a question.
Well, when we're successful, it feels really good. Unfortunately, we're not always successful, and that feels terrible. But the successes keep us going.
Do you think that we should do more in terms of supporting public defenders, give them more incentives or opportunities so that they would come forward and willingly support someone who is wrongfully convicted and has evidence of his innocence?
Well, I always think public defenders should have more access to resources. I don't really think that's the core of the problem.
What do you think is the core of the problem?
The criminal justice system is run by prosecutors and police. I think that's the core of the problem.
What do you think is the future of the United States criminal justice system?
Obviously there's a lot more awareness now of how unjust it is. We had a criminal justice reform agenda at the legislature this session. I'm talking about us, the Innocence Project of Texas. We had about 3 or 4 bills that we were really strongly advocating for. All those bills got killed, or it appears they've been killed. There's, I guess, another 3 or 4 days when they could get through. And so I don't know. I mean, it just tells me, despite all the big talk and press conferences after the George Floyd murder, that when it came down to it, the people in power, some of the people in power, there were a lot of good people pushing our bills and supporting our bills, but there were enough people in power who oppose criminal justice reform that our bills got killed. Until those people start paying a political price for doing that, I don't think anything's going to change.
This is Fair Play on JusticeNews.net.